Okay, everybody, it's 12:01, so I'm going to go ahead and get started. We do have quite a number of participants on today, and I'm not surprised as we all try and figure out our new world. I just want you to know that we here are all anxious and stressed out and depressed and dealing with this new reality just like you are. We understand. If you want to give us a call and just chat about the challenges that you're facing, we'd be happy to discuss just coping mechanisms. I mean, it helps us as well. And we certainly, in this very challenging time, are wishing the best for you to be safe and healthy and your families as well. So I wanted to present today on the board's challenges that it has been facing, which have now become our challenges because the board has issued a number of directives regarding changes that it's made as a result of responding to COVID-19. So this is going to be specific to New York workers' compensation. I am aware, and I'm sure you are as well, of a number of legislative changes that have been enacted by both New York State and the federal government. And that changes minute by minute. And in fact, we had a change that the board implemented this morning, which we're going to discuss. But that is beyond the scope of this presentation today. I'm limiting my comments to the board's treatment and the changes that it's made in response to the epidemic. Not that I'm not willing to talk about other issues that have arisen which affect our practices, but it's just beyond the scope of this presentation. But if you want to call me, I have had numerous conversations with clients about the impact of the legislation, and we've put our heads together to try and figure out exactly what it's going to mean. So let's start. What is COVID-19? What exactly are we dealing with here? Because coronavirus, as many of you know, I'm sure, has been around for a long time, but this is a new presentation of the virus that the World Health Organization is now referring to, the disease that you contract from this virus, as COVID-19. It's a serious respiratory illness that causes very significant pneumonia, and that is what is making it so challenging for people. This was first identified in China in a very localized outbreak, which then became international. I want to look at a relevant New York timeline. So I've only highlighted dates here that are really relevant to our presentation today. The amazing thing to me is how quickly this has all happened. On December 31st of 2019, that was the first time that China informed the World Health Organization of a cluster of 41 people who had developed a mysterious pneumonia-like condition. And most of those people at that time were affiliated with an open air market. By January 11th of 2020, China recorded its first death. And by January 20th of 2020, the United States had its first reported case. Those early cases were related to people who had traveled to Wuhan province in China. By January 30th of 2020, the World Health Organization had designated COVID-19 as a public health emergency of international concern. Prior to that, people believed that it would be limited to Asia. Thailand and Japan had outbreaks as a result of travelers from Wuhan province. But by January 30th of 2020, it was considered an international problem. By February 29th of 2020, the United States experienced its first death on American soil. An American national had died who was living in China before that. So that was our first death here in the United States. And that was literally less than 1 month ago. By March 1st, we had our first COVID-19 reported case in New York. It's quite likely we had cases before that, but that was the first one that was actually reported. By March 7th of 2020, a scant 6 days later, Governor Cuomo declared that New York was a state of emergency. March 12th of 2020, Governor Cuomo prohibited gatherings of in excess of 500 people, and by March 13th of 2020, President Trump declared a national emergency in the United States. That was a Friday the 13th. March 14th, New York experienced its first 2 fatalities. There were 2 fatalities that day. And the next day, on March 15th of 2020, which was a Sunday, the board issued its first public response to the epidemic. And we're going to discuss that in depth today. On March 16th of 2020, all counties in New York State had declared, by March 16th, some had done it earlier, all 62 counties in New York State had declared states of emergency, and the board closed its offices physically to the public. By March 20th of 2020, Governor Cuomo mandated that all non-essential workers work from home. And essential workers, you can look up that definition. It's kind of confusing, but many of you, I am sure, if not most of you, fit into the essential business exception because you are considered financial institutions. March 21st of 2020, the board issued an emergency relief from having to provide original signatures, and we'll talk about that more in depth as well. And by March 26th, which was yesterday, the United States led all countries in reported cases of COVID-19. This morning, March 27th, this morning, March 27th of 2020, the board issued guidance on labor market attachment, which is not good news for us, as you might imagine. And looking into the future, I believe that as of April 1st of 2020, we will likely see additional legislation in New York dealing with COVID-19 and a presumption of compensability under the workers' compensation law, and we'll talk about that as well. Way back in the beginning, when the pandemic first started, one of the concerns that my clients were coming to me with was whether or not if somebody developed COVID-19, we thought that they would be able to make a claim for workers' compensation benefits. And I mean, the answer to that was possibly. We noted that it's always the claimant's burden of proof to demonstrate causal relationship between their employment and any occupational condition, and such that proof would have to be developed, which would show that there was a link, not necessarily to the exclusion of all other causes, but that it was likely or not that the claimant developed that condition as a result of an exposure at the workplace. That was going to be a fairly significant bar given the prevalence of the spread of the virus in New York State and in the country. We looked at whether or not a COVID-19 claim would be established as an occupational disease or as an accidental condition, and our opinion on that is that it could be potentially established as either. If it was claimed as an occupational disease, the individual, the injured worker, would have to show that the condition arose as a result of a distinctive feature of their employment, just like with any occupational disease. And as you might imagine, that would be limited to people who would have potentially exposure to communicable diseases as a result of the features of their employment, like first responders. So potentially nurses, personal care, PCAs, CNAs, EMTs, doctors, nurse practitioners, in addition to potentially some other types of first responder workers like firefighters, police. They likely might be able to show that exposure to a communicable disease was a distinctive feature of their employment. Regarding whether or not it could be established as an accidental condition, we believed that if an individual was able to show a documented case of COVID-19 at their employer, and that their interaction with that individual in their employment was the likely source of their contraction of the disease, they might also be able to establish an accidental claim for a COVID-19. But that was back in the beginning. Our concerns now have broadened because of the extent of the virus here in New York as we've become an epicenter. On March 15th, as I noted, the board issued its initial response to COVID-19, and it made a number of changes. The first of those was that the board took its virtual hearing technology and required that all hearings be held by remote attendance. So the board has, as we all know, implemented virtual hearing technology, but parties still had the option of whether they wanted to appear in person at a district location or whether they wanted to appear virtually. And we have had the experience recently where judges have insisted upon in-person appearances for our employer witnesses or for our investigators when we've raised fraud. And our review of the decisional law on whether or not a judge could require an in-person appearance was that attendance by a virtual hearing was considered an in-person appearance. So a judge could not direct a witness to appear personally at a workers' compensation board hearing location. Unless there were some very unique extenuating circumstances, which I think would have had to have been articulated by a judge, because the board has held that attendance by a virtual hearing is an in-person appearance for purposes of attending a hearing. What has not been permitted is that the parties have not been permitted to appear by telephone without prior permission. So not that you couldn't get permission for a witness to appear telephonically, it would have to have been granted by a judge ahead of time, but what should not have been required by a judge is permission for a party to appear virtually. Now, judges absolutely can't require anybody to appear in person because the board is no longer allowing people to appear in person. So all hearings as of March 15th, well, that was a Sunday, so March 16th, all hearings are now conducted virtually. You cannot elect to appear in person. There are a small number of cases that the board set, and I haven't discussed any disability claims, discrimination claims, Section 120 claims with clients where personal appearance has still been required at the board. The board noted that it would reach out to the parties on those kinds of cases to let them know how it was going to handle having a hearing. But for workers' comp claims, all appearances now are virtually. The board did permit claimants to elect to appear by telephone. That is not true for all parties because according to the law as it stood before this directive, and as well as the explicit language on the board's website regarding appearance by virtually, only claimants are given the option of appearing by telephone. So if you have witnesses that are going to be appearing, or you have fraud that you're pursuing and you need investigator testimony, you must make sure that they're able to use the board's virtual hearing system in order to appear. If you have physical evidence that needs to be produced, the board's directives indicate that should be provided within 2 days of introducing it at the hearing. And the board's stated goals in continuing to hold virtual hearings is to prevent the need to cancel hearings as a result of this outbreak. The board doesn't want to delay the provision of benefits to injured workers. And some of the other changes that we're going to take a look at definitely seem to keep that overarching priority in mind by the board as it requires certain continuing benefits to be paid despite some deficiencies which may have led to a cessation of benefits in the past. Right, so the board then also addressed specific concerns, one of them being the 90-day requirement for medical evidence. So we all know that claimants have to produce medical evidence every 90 days unless they've been classified with having a permanent partial disability in order to be entitled to ongoing benefits. We do know that judges will sometimes allow a claimant for a short period of time to have ongoing benefits, even with a lack of medical, if there's some sort of indication that the claimant is about to or has just seen a physician and there just isn't a report yet. And what's, I guess, important to know about the 90-day requirement is that the board did not suspend this requirement. However, they did specifically state that they understand there will be situations where it will be difficult for a claimant to see his or her attending physician every 90 days because of the outbreak. So specifically, the board states this could be due to the physician's unavailability or because the claimant, his or herself, is quarantined. If that's the case, the board is going to take into consideration a claimant's assertion or his or her attorney's assertion that the claimant was unable to secure the required medical report as a result of the coronavirus outbreak. So it will be important for your counsel, defense counsel at hearings, to be aware that I wouldn't take a bald assertion by a claimant's counsel or by a claimant that they were unable to comply with the 90-day requirement. I'm going to request some testimony from the claimant, or at least a modicum of proof that the doctor wasn't available, like a letter from the doctor's offices or some other kind of documentary evidence that the claimant was unable to comply with the 90-day requirement. And this is especially true in light of the board's enactment of an emergency regulation providing for telemedicine. This was effective 90 days upon its adoption in March 16th on 2020. We're just going to take a look at that a little bit more in depth. Bear with me for a second. I just want to. Okay. The board did enact an emergency regulation allowing for telemedicine. It's section 325 1.8 and some other provisions regarding the payment for such telemedicine visits under the fee schedule. And what it provides is that an authorized provider, is the language used, can use interactive audio and video telecommunications, that to me means that you have to have both audio and video. You cannot just have a telephone call with the claimant. So an authorized provider can use interactive audio and video telecommunications to permit real-time communication between the provider and the claimant, and that can be used to assess current disability status in medically appropriate situations. So what is medically appropriate? The regulation provides examples of what it considers medically appropriate, but it's examples, it's not an exhaustive list. It says discussion of tests or imaging, follow-up assessments, not an initial assessment, or counseling. The regulation also provides examples of what is not considered medically appropriate for telemedicine visits, and that would be an initial visit, something where a physical examination is a necessary component of the treatment, like an initial visit, physical therapy, or some other type of manual therapy. So it's difficult to understand how an acupuncturist, although they would be an authorized provider, could do telemedicine. Lastly, in the report, the authorized provider must indicate, and I don't know, I've already seen a telemedicine report from a provider, and it did include this language in there. It has to include an indication in the report that the assessment was done using telemedicine as a result of social distancing due to COVID-19. So if the report doesn't indicate that, then it wouldn't be appropriate a telemedicine proof. We're going to come back to telemedicine in a minute. The board has, as part of its March 15th, 2020 directives, also provided information about the failure to attend an IME. So the board notes that the workers' comp law provides that a refusal by a claimant to attend an IME can lead to a cessation of benefits. I liked this acknowledgement and concession by the board that on its website, it indicates that while a number of non-appearances is not specified in the rule, it's usually only entertained, a request to suspend benefits is usually only entertained after 2 non-appearances. I'm glad that the board acknowledges that that's not in the rule, because certainly we've advised clients when you're voluntarily paying at the beginning of a claim and an individual has failed to attend an IME, that that's a basis for you to be able to suspend benefits. But regardless, we're in different territory right now. The board notes that there have been circumstances where it suspends benefits to the claimant as a result of a refusal to attend an IME exam. The board also notes, though, that there's no basis to suspend benefits where a claimant's refusal or inability or failure to attend an IME is reasonable. And of course, the board is teeing this up for the idea that an inability or refusal to attend an IME as a result of COVID-19 could be reasonable and so therefore should not lead to a cessation of benefits. Originally, when the board published this directive, it indicated that if a claimant could not attend an IME due to the coronavirus outbreak, that he or she should let their attorney know, and that the IME doctor and the board should be notified by letter as a result of the inability to attend the IME. So that seems to suggest some prospective effort on the part of the claimant and or his or her attorney in order to provide the requisite proof that the COVID-19 prevented them from attending an IME. The board then indicated, as part of this, these recommendations, this information that it was providing on March 15th, that benefits would not be suspended to a claimant as a result of a failure to attend the IME if those proofs were submitted. The board also addressed carriers' potential inability to get and schedule an IME within 30 days after receipt of a C4 auth. This is an interesting issue, seeing as it's our understanding in New York State right now that no elective surgeries are proceeding, and most of the surgeries that claimants would undergo in a workers' comp context would be considered elective procedures. So many of the C4 auths that you receive, first of all, I would suspect that you'll see a diminution in the number that you receive, but also I've already had a hearing on this issue, and judges have noted that this issue is moot for the time being. That doesn't necessarily mean that you're not going to get C4 auths, because certainly I have seen them. And when you do receive them, the board has stated that despite the challenges that you might experience in scheduling an IME, and we're going to get into that a little bit more in depth in a minute, that does not relieve you of the obligation of having contrary medical evidence when responding to a C4 auth. I would just like to take this moment to point out that frequently when you're responding to a C4 auth and you're getting medical evidence, the C4 auth is requesting a certain procedure. And the purpose of the board's regulations and procedures for reviewing a C4 auth is to determine whether the proposed surgery or special service is medically necessary. So is it something that is appropriate under the medical treatment guidelines? You should understand that there's a distinction between whether or not the proposed treatment is reasonable under the MTGs from whether or not the proposed treatment is causally related to your claim. I've seen it both ways. I've seen situations where it was clear that the treatment was medically necessary and it was appropriate under the MTGs, but there'd been a 3-year lapse in treatment and an intervening return to different employment, such that there was a very significant question about whether the proposed treatment was related to the compensation claim. Even if you don't have contrary medical, in response to that C4 auth, saying that the procedure isn't necessary, that doesn't defeat your ability to challenge causal relationship of the proposed reasonable treatment with respect to your particular claim. I've seen it the reverse. I've seen it where it's uncontestable that if the treatment is appropriate, it's related to the workers' compensation claim because there was no evidence of any other intervening potential cause. However, the request itself, because it was a second procedure, it failed with the burden of proof for being considered medically necessary or reasonable under the medical treatment guidelines. So please keep in mind the difference between the need to respond to a C4 auth, which only determines medical necessity, and whether or not something is causally related to your workers' compensation claim. You may decide that you do not want to controvert the medical necessity of a procedure, but you do want to preserve your challenges to causal relationship. What the board has held, or what it's stated rather, in this these recommendations that it's promulgated as a result of COVID-19, is that it does not have the authority to suspend the statutory requirement for contrary medical evidence within 30 days of the request for treatment. So if you want to controvert medical necessity of treatment, and you don't have procedural grounds upon which to challenge the C4 auth, and you could refer that to your defense counsel to see whether or not you do have a burden of proof kind of defense. Then your only option, if you cannot get an IME scheduled, is to get a record review. Frequently, record reviews are efficacious in situations where you're trying to determine medical necessity, because you do not need a physical examination of the individual in order to determine the appropriateness of the medical treatment. The board also looked at other situations where carriers are looking to get IMEs. We've gotten some conflicting information on this. We received an email very recently from an IME provider vendor that indicated that they were still scheduling in-person evaluations. I tend to think that that's as a result of optimistic beliefs about whether we're going to continue under the same kinds of restrictions that we are currently under. Because I've had other IME companies and vendors, I've had discussions with them in which they've informed me, and I've seen the emails from the board which indicate that although IME providers are considered essential, IME vendors are not, and they are not permitted to operate. And in addition, the state has informed IME vendors that in-person IME evaluations are not permitted. Now, this is an issue we ran into with the labor market attachment issue that we're going to discuss towards the end of today's presentation. The board has not issued any directive or indication stating that in-person IME evaluations are not permitted. I also have not seen anything from the governor's office that explicitly states that. Now, obviously, IME providers, doctors are people, and they may not want to be doing in-person evaluations, and I certainly can't blame them. However, these are, you know, we're facing a number of significant challenges, and I guess the question arises as to whether or not we can arrive at, or we can propose reasonable alternatives which would keep everybody safe during this obviously very challenging time. And certainly we're aware that we could do record reviews, but on occasion a record review simply isn't going to suffice for the issue before the board, such as a permanency evaluation. You really need to have an in-person examination of an individual, although I could I guess envision a situation where you might be able to do limited permanency evaluations depending upon the body site involved by telemedicine or by a remote evaluation. So certainly we're aware that we can have record reviews, but the question is whether or not we can have an IME. So this is where it comes, you need to have these conversations with your preferred IME vendors and find out what their position is. As I said, my understanding is that most IME companies at this point have been told that they cannot have in-person evaluations. Additionally, I've had a conversation with an IME vendor whom I trust, who has told me that they reached out to the board to see whether or not telemedicine would be permitted for an IME, and the board got back to them and said no. But again, this is a situation where under what authority is the board prohibiting a telemedicine IME? So let's just go back to the telemedicine regulation, emergency regulation that was promulgated for a second, and just see whether or not, you know, we find anything within that regulation that would prohibit a virtual IME evaluation. So the regulation, it says telemedicine using interactive audio and video between an authorized medical provider and a claimant. IME doctors are authorized medical providers. It doesn't say an attending authorized medical provider, it says an authorized medical provider. So I do not find language within the regulation permitting telemedicine, which would preclude an IME doctor from doing a telemedicine evaluation. Now, just like with an attending physician, there are situations where an in-person or a virtual IME is not going to suffice. It will be so without value that it would lack credibility before the board. And again, that would be for a kind of an exam where an in-person evaluation is really required, like a permanency evaluation where you're evaluating range of motion of the hip or of the shoulder. I cannot imagine a telemedicine kind of evaluation by any doctor, attending or IME, where a virtual evaluation of range of motion of a major extremity like a shoulder or a hip would be credible. However, for the hands or for the wrists, a virtual evaluation might be more credible because it would be easier to evaluate range of motions for a more localized extremity. Regardless, if it's a telemedicine evaluation by an attending physician or hypothetically an IME doctor, if it's to discuss the results of an MRI study, to do a follow-up IME, those seem to me to be situations that lend themselves just as well to having a virtual IME as an attending physician. So the question is whether your risk tolerance would lead you to decide that you might want to go ahead and try and pursue a virtual IME, or whether you want to avail yourselves of the board's liberal provisions at this point for obtaining extensions of time in which to perform IMEs. And I would think that as the longer this draws out, the more we continue to be limited in getting access to have evaluations done, that we may see additional guidance from the board on these instances. Lastly, the board addressed getting IMEs in controverted claims and unpermanency, where there's been an actual direction by the board to obtain an IME. So in controverted claims, we know that we have very limited time to get an IME exam, and it's generally, it has to be in the board file 3 days prior to the first expedited hearing, which is a term of art, and it means it's actually the day upon which the lay witness testimony would be taken. So you have your pre-hearing conference, which occurs initially, where the issues are limited by the parties and where you identify the evidence that you intend upon producing in support of your controversy. And then within 30 days, the board is supposed to schedule the first expedited hearing, which is the hearing where the testimony takes place, your lay witness testimony. And it is required by statute and regulation that you have your IME, if you intend upon getting one on the issue of causal relationship, to all parties within no less than 3 days prior to that first expedited hearing. So that is a situation where the board requires an IME. Additionally, the board is saying that permanency evaluation, so if you've received an EC 81.7 or a proposed decision, sometimes is how these are issued, where the board notes that there is evidence of permanency from an attending physician. If you accept this evidence, please file an RFA and notify the board. If you do not and you intend upon getting an IME, then one must be obtained within 90 days of this letter. That is a situation where the board has directed you to get an IME on permanency. What the board's direction has said in connection with its response to COVID-19 is that extensions of time in these situations where you're unable to get an IME will be granted if you can demonstrate that your inability to get the claimant evaluated was as a result of the coronavirus outbreak, as a result of COVID-19. Be aware that this has to be done by an affidavit. So you're going to need the assistance of your defense counsel in order to prepare these extensions. However, if you follow the instructions that the board has presented here in its directions, you should be granted an extension of time. What they're going to do with additional requests for extension of time will be interesting, especially in controverted claims where benefits are held up while the controversy is determined. Because as we know from the very beginning of our presentation today, it is the board's intention to not cancel hearings and to continue to provide benefits to injured workers uninterrupted. Depositions, this is relevant, very relevant for your defense counsel and for our friends who have in-house counsel who represent them. When we are trying to schedule depositions, and we've run into these issues already, we have encountered difficulties in getting doctors' offices to provide us with dates for depositions. Once again, the board has indicated with respect to its response to COVID-19 that it's going to entertain requests for extensions of time. And again, I believe it's important that you demonstrate the specific issues that you've run into as a result of COVID-19. I wouldn't just blanketly state that you have been unable to schedule a deposition of the doctor as a result of the prevailing conditions. You should provide specific information saying that the doctor is volunteering services at Mount Sinai Hospital, or the military physician who performed the IME has been limited in being able to perform any outside work during the COVID-19, or I had a conversation with office manager so-and-so at the doctor's office and was informed that the doctor would not be complying with any requests for depositions because he's unable to travel because he's quarantined, or something specific, not simply baldly assert that you're unable to get the deposition scheduled because of the COVID-19 situation. Appeals and rebuttals, the board provided has provided an indication that it will relax its strict requirements regarding the timely filing of an appeal or a rebuttal. I don't really think that this is very, I do not see this arising as an issue very frequently unless you're having difficulty with your mail. If for some reason you are unable to get mail at your office as a result of having a limited workforce available to actually go through your mail, and you can document that that is as a result of the requirement that everybody work from home, you may be able to demonstrate that you should still be permitted to file an appeal once you do get the decision and you make a decision that you want to file the appeal. It seems to me that would be a relatively unique situation. And additionally, because you are generally all essential businesses, you may not be relieved of the requirement to have a sufficient work staff at your office that is going through the mail. But you should understand that, certainly if we can find a way, or your defense counsel can find a way to demonstrate that as a result of the situation, the COVID-19 situation, that this led to an untimely filing of a potential appeal or rebuttal, the board is going to entertain, let's put it this way, the board will not summarily dismiss your appeal. It will first consider whether or not it should summarily dismiss your appeal, which, if you've had any experience with applications for review and rebuttals lately, which I'm sure you all have, that is a difference in at least having them take a look at it to see whether or not you should be given relief from the 30-day filing requirement. The regulation already provided for service of parties by electronic means is the language in the regulation, which could be fax, email, I guess I'm not really sure, I don't know, direct up or Google Docs sharing or something like that. But you have to have the explicit permission, is the language in the regulation, from the party in order to do so, and you have to provide a certification that you had explicit permission along with the filing of the application for review or the rebuttal. Bureau of Compliance. I'm going to try not to keep everybody more than an hour today, because I do know that working from home can present some efficiency challenges. that you don't have in the office. Bureau of Compliance is simply, it just permits an employer who's been penalized as a result of failure to provide coverage or failure of a carrier to provide requested documents. If a penalty has been assessed, you can request a redetermination by showing that your delay or your inability to respond was due to the COVID-19 situation. And again, you would need to provide that by affidavit. Payer compliance, this is your timely SROIs and FROIs. Certainly I can imagine situations where your insureds, where your clients have encountered situations with being able to provide you timely with documents as a result of the outbreak, or you yourselves have encountered situations where you're unable to timely produce your first reports of injury or second reports of injury or to commence payments in a timely fashion. And if that is the case, then the board will consider applications to relieve you of having to pay the penalty to it, but not any penalty that might potentially be due to a claimant as a result of the late payment. If you know, the question is going to be whether or not it's worth, if it's cost effective to you to prepare the affidavits you're going to need to prepare in order to be relieved of the penalties. And I can certainly envision a situation where, you know, there's an entire, you know, week's worth of electronic filings that for some reason don't get properly uploaded into the board sites, and then you want to challenge penalties associated with all of that data. Because then you would only have to do one response, because the board will accept multiple submissions in one application. However, if you're talking about a single late SROI or FROI or timely payment of benefits, it doesn't seem that it would be worth it or cost effective to challenge the penalty that is only payable to the board by producing an affidavit. It's one of those, you know, it depends on the fact situation. Those were all the changes that were implemented by the board on March 15th of 2020. And then it also has continued to update its website with additional changes and requirements and information in addition in other situations. One of those things was emergency relief from an original signature on listed documents. And this was implemented in addition to the New York Unified Justice Court system, also allowing for notarization of documents by video conference, which was never permitted in the past. And the board has also discussed in its in the information that it's promulgated in response to COVID-19, an indication that that notaries could be done by attorneys when they're supervising staff. But since that time, the courts have issued, or the governor has issued guidance allowing for video notarization. So there's no longer the need to comply with what the board had presented early on with respect to notarizing documents. None of this is all that relevant to you know, each of our clients, unless you have attorneys in your office who are notarizing documents. But suffice to say that there are provisions now. The governor has issued guidance on allowing for notarizing documents, and if you want additional, notarizing documents by video, and if you want additional information on that, you can give us an email or a telephone call following today's presentation. What the board has issued, which is relevant today, is that there is emergency relief from the requirement that an original signature be listed on certain documents. We've been doing electronic signatures for a long time here at this office, and the board routinely accepts electronic signatures as original signatures, and really that's in keeping with like kind of law school 101. What I learned in law school was that somebody's signature is what they intend to be a signature. So I could put an X on a piece of paper or a paw print with my dog on a piece of paper, and if that's what I intend to be a signature, then that's my signature. However, to make things a little bit more complicated for you, not necessarily for the claimant, if your original signature is required on a document, then not only do you have to comply with the regulation regarding electronic signatures, which is really just by affixing your electronic signature to a document, you intend to be signifying that that signature is your signature. So that's kind of silly. But you also have to provide this attestation, which is on the board's website. There aren't a ton of situations where you need to provide original signatures where we can't do that for you. But in those situations where you do, I would reach out to your defense counsel, or if you're unsure at all about what you need to do for an electronic signature and for providing this attestation that the board is requiring. Just an example of some of the documents that the board does require an original signature, or that it asserts that it has to have an original signature, are things like C3, Section 32s, the claimant's C32.1s, where they're they're going through all those questions that they understand that they're giving up all their rights, et cetera, et cetera. Stipulations, Form 300.5. Which we affix electronic signatures to all the time without an attestation, but it's probably wiser now to include that attestation. OC 400.5s, which are forms that we have to file in connection with pre-hearing conference statements. If you do sign your own pre-hearing conference statements and you submit those to the board, it would probably be smart to include this attestation with the document. And you may have to do that on a different paper depending upon your Adobe resources. Okay, as of this morning, the board issued a new directive regarding labor market attachment proofs. And we've been experiencing this. We sort of sniffed out that this might be coming down the pike because judges had been refusing to entertain many of our labor market attachment arguments or continue the case for this issue when it was raised at the hearing. And so what today's, and it's not a subject number, it's interesting because it is included in the board's COVID-19 responses on its website. So when you go to the home page of the Workers' Comp Board's website, you will see, I think there are 5 documents now from which all this information was taken, including this information on labor market attachment. It is listed among the link is provided for this information regarding labor market attachment, and it takes you to the regular the page that addresses labor market attachment. So it's not a subject number or anything like that. It's difficult to find on the board's website, but it's there. And what it says is that because of the state of emergency and because Governor Cuomo has directed that non-essential businesses remain closed, that there's been a disruption in normal economic activity, and that as a result, claimants may not be able to conduct a successful job search or participate in job placement or vocational rehabilitation. So as a result, the board is not going to require injured workers to demonstrate that they are attached to the labor market in order to maintain permanent partial disability benefits during this emergency period. So right away, temporary partial disability benefits, if you wanted to challenge labor market attachment, I do not believe that you can raise that issue anymore without reprisal from the board. Whether or not the board has the authority to do that, whether or not the governor has this isn't from the governor, this is from the board. So whether the board has the authority in response to the disruption in normal economic activity under New York's Constitution to deprive you of property without due process of law, whether or not they have that authority, they believe they have it. And so I believe that you challenge the board's refusal to entertain your labor market attachment arguments at your own peril, because I do assume that the board will penalize you for challenging the refusal to consider labor market attachment as a defense. That doesn't mean you shouldn't. things only get declared unconstitutional when people are willing to face the potential consequences and risks that are associated with challenging the constitutionality of something. Our first statute, the first workers' comp statute, was ruled unconstitutional after an employer challenged the authority of the state to require it to make payments to the claimant on that very theory that it was a deprivation of property without due process of law. And it was really as a result of a lack of authority of New York State to require employers to provide for benefits without regard to fault that led to our Court of Appeals finding the statute, our first statute, unconstitutional. And ultimately, our Constitution had to be amended to give New York that power to enact a comp regulation, or excuse me, comp statute. At least the board recognizes that labor market attachment is an issue which must be adjudicated prior to a finding of permanency. And what it's found is that given that statutory requirement that labor market attachment be determined at the time of classification, or at least immediately prior to classification, the board has indicated that it will adjourn the issue of permanency until such time that labor market attachment can be determined. Now that seems like, well, at least we'll be able to get a ruling on labor market attachment at an appropriate time, but the issue with that is that you will be required to continue to make benefits at a temporary partial or temporary rate until such time that the claimant is classified. And how many additional weeks might that add to your weeks of benefits that you have to pay, where you would normally be allowed to get the person classified and start counting those weeks toward the caps, whatever caps you end up having to face. So that may be an issue for a later day, where we will make arguments in the future once this emergency is over that your caps should start at the earliest point in time. You know, certainly for cases, and I forget the specific date, in 2017, I think it might be April 1st of 2017, there's a presumption that all benefits paid in excess of 130 weeks from the date of accident, those are counted against the caps. So we may end up finding that we're litigating MMI more frequently, or it may be more important for you to litigate MMI so that you can make an argument once the emergency is over that even though the claimant will not be classified until some date in the future, the weeks that you are required to continue paying as a result of the delay in the permanency finding should count against your caps. Lastly, what's coming in the future? It's our understanding that legislation has been proposed as part of the budget legislation that we have every year in New York. So New York's budget is due on April 1st of every year, and in connection with budget negotiations, there is invariably a large amount of legislation that gets passed on April 1st, usually, of any given year. I think last year the budget may have come in a little bit late because I think that at the time we still had split rule between the parties in the legislature and the Senate of New York, and the parties were unable to come to an agreement about whether or not marijuana should be legalized. Marijuana, I think, was well on its way to, in all likelihood, be legalized recreationally here in New York State as part of the budget bill this year. However, certainly this situation has thrown many things regarding the budget bill into disarray. One of the things that has risen up as a possibility with this budget bill, and it seems likely that it will pass, is the creation of a presumption of an occupational illness for COVID-19 for certain classifications of employees. This would be employees that you think would be at risk for developing COVID-19, like healthcare providers, not necessarily transportation services, but it's essentially all essential businesses. So to the extent that a financial institution and yourselves, like insurance carriers, are considered essential businesses, if you have an employee who develops COVID-19 and this legislation passes, then the person would be entitled to a presumption of compensability of an occupational illness. I would imagine there would still be an ability to rebut that presumption, but as with other presumptions in the workers' compensation statute, I do believe that there would be a high bar for us to overcome those presumptions. Not that we won't try under the appropriate circumstances. Certainly, if this becomes law, and it seems likely that it will, and you have healthcare providers who are in emergency room situations and they're dealing with very sick patients and they develop COVID-19, it would seem very difficult, not just legally, but morally, to want to fight that kind of a claim, given the kind of courage that I think that it requires in order to be able to go into those kinds of situations and to continue to work. However, under different circumstances, it's certainly something that might be worth considering trying to overcome. So that is all for right now. We brought you right up to today, actually brought you up to April 1st, which is next week, and what we believe might happen coming into the very near future here with respect to workers' comp and COVID-19. And if you have any questions, you can please feel free to email either me or my partner, James Cousins, who's been very dutifully attentive during today's presentation, although unusually quiet. Or you can give us a call at 71. Oh, maybe you can't be unmuted. Is that the problem? Or you can give us a call at 716-616-0111. What we would ask that you not do is come to the office. Give me a second here, and I'm just gonna unmute Mr. Cousins. There you go, James. I thought you were being unusually quiet.
Oh my God, I've been making comments about how pissed off all this stuff makes me for the last hour. And then
well, it's probably good that I didn't have you allowed to speak because
yeah, it's probably good because I was screaming about, like, let's just raise labor market at every hearing and tell the client to suspend. And I was just thinking about the appellate division asking the board the same question that they're asking us to answer in all of the extension requests. You can't just claim COVID-19 and say, I can't get the doctors set up timely, or I can't get an IME or whatever. The board right now is doing the exact thing. They're going, yeah, we can't deal with labor market attachment because of COVID-19. Well, why? You're telling us on one hand that everything is going to continue as normal, and you're insisting that it's important to give benefits to these people. Hearings will continue, but labor market attachment, what is that, special? You know, like, especially for labor market attachment that predates the dates of declared emergency. But I'm sorry, this stuff gets me upset because it's all about giving claimants money and giving us a hard time dealing with it.
I'm going to unmute everybody and just see if there are any other questions that anybody else would like to bring up. Everybody be aware that you are all unmuted now.
Hi, everyone.
Hello.
Hello.
Does anybody have any questions?
Is this shareable? This presentation?
So I will, I've been recording the presentation. The recording will be available on our website. It does require a password. I can provide anybody who wants it with a copy of the PowerPoint presentation. If you could just shoot me an email at mday@madwcdefense.com, and I'd be happy to give you one.
Thank you.
Certainly. All right, well, if anybody doesn't have any questions that they want to ask right now, but if something comes up, as we just mentioned, please feel free to shoot us an email or give us a call. And we hope that everybody continues to stay safe and healthy. We're all in this with you. Thanks, everybody.
Thank you.
Thank you.
Bye, everyone. Stay safe.
You too.